might have heard, we've bitten off quite a lot with this enforcement subject, so we're going to try and keep it strictly to under an hour. And we'll leave 10 minutes at the end of the hour for questions. Although, as I say, we've had quite a lot of good questions, and we'll answer those either as we go through the presentation or at the end of the presentation. We chose this topic because enforcement is something that needs to be considered in virtually all civil litigation, unless you're dealing with a large insurer or the Crown or something like that. But you're all here, so I'm sure you understand why it's an important subject. So without any further ado, we'll jump into the presentation. All right, so interim injunction, freezing orders, these are an interim injunction that prevents a party from disposing of or dealing with assets that they control so as to defeat any eventual judgment. Also, they invariably require the respondent to immediately provide information about their assets and give the value, location and details of those assets. That's quite an important feature. I've got something in the Q&A. That's quite an important feature because, sorry, I can see a question from Jeet. We'll try and come to those questions at the end of the presentation. So yeah, the fact of the requirement of the disclosure of assets is quite important, because that information, for example, if the respondent gives details of a bank account, the applicant can then secure money in that account by way of a subsequent third-party debt order. So as an interim, which I'll come to later on in this talk, so as an interim injunction, the applicable rules are found in CPRs 23 and 25. It's worth looking at the standard freezing order template, which is in the practice direction 25A. That's a very detailed order that will always be the starting point for a freezing order. It's in the annex, and you'll see it's the template envisages that it'll be dealt with a High Court judge. It's almost always the case that it will be a High Court judge, given the seriousness of a freezing order and the likely value of the assets involved. Although I should say it is possible to have a circuit judge grant a freezing order. So in terms of when a freezing order will be granted, the main question for the court will be whether it's just and convenient to grant a freezing order. There's no limit as to what the court can consider in terms of whether to make an order, but it's essential for the applicant to show that there is a risk of dissipation. Examples of factor which might show that there is a risk are where the respondent has been using complex offshore financial arrangements, particularly in opaque jurisdictions like the BVI. Any failure to file accounts when obliged to do so, which show that the respondent is in breach of a requirement to declare their assets or liabilities. The respondent's credit record can be relevant. Any evidence of an intention to dispose of assets. Now, it might sound surprising that a respondent would tell you in advance of their intention to evade enforcement, but I think, I'm sure we're all familiar with cases where we're in settlement negotiations and the other side might say something like, it's either this or nothing, and perhaps threaten to burn a company or something like that. That was considered in Motorola and Hytera Communications, where there was such evidence from without prejudice proceedings, and the court found that in that case that was an exception to the without prejudice rule, which fell within the unambiguous impropriety exception, and that disclosure could then be used as the basis for a freezing order. Also very relevant is any evidence of dishonesty. That could be in the form of criminal convictions for fraud, or it could be during proceedings if there's a finding of dishonesty made, or at the conclusion of trial if there's a finding of dishonesty made in relation to some of the witnesses or one of the parties. It's important to say that none of the above will necessarily show that a freezing order should be granted, but they're all the kind of factors that you'd expect to engage when if you're trying to show the court that the respondent can't be trusted not to dissipate or make their not to dissipate their assets or make their assets more difficult to enforce against. As is always the case with equitable remedies, delay will weaken your case. Firstly, because that's a maxim of equity, but secondly, because of course it undermines your case as an applicant. If you're going to the court and saying, I'm concerned that the respondent is going to dissipate their assets some 8 months after you've first engaged with them or become aware of their wrongdoing, if they haven't done it after a long period of time, it's inherently unlikely that another few months or however long it takes to get to judgment or enforcement, that they'll do so within that time. As I think I've said already, they're not to be sought lightly. They're extremely onerous and invasive remedies, and invariably you'll need to make sure that the sum you're pursuing justifies the work and cost and invasiveness of a freezing order. So turning then to what assets can be frozen, it's worth pointing out that it's not necessary for a freezing order that the respondent actually owns the assets. It's enough that they have control over the assets. They're not limited to assets within the jurisdiction. They can be worldwide assets. Assets can be jointly owned or held on trust for the respondent. And it's worth pointing out that normally almost always it's the case that the assets frozen will be limited to a certain amount, say £1 million or £500,000 or whatever. That calculation will be arrived at by assessing the likely claim that will need to be enforced. So say, for example, there's a likely cost order of 200 grand and a likely liability order of 100 grand, then you would freeze the assets of the respondent up to 300,000. There are exceptions, of course, so where you've got a complex fraud claim where you don't yet know the value of the assets that have been taken or the extent of the equitable claim that you might pursue against the assets, then of course you can have a general order extending to all of the respondent's assets, but as I say, that's relatively rare. You can also have a freezing order made against the assets of a third party, so someone against whom you don't have a cause of action. Again, the point to remember is it's about the enforcement principle, not about the cause of action. So it's if there is a third party that you suspect holds assets in truth for the person against whom you're going to seek enforcement, then you can get this chapter order against those assets. So things that you'll need to get your freezing order, primarily an affidavit, a sworn affidavit with exhibits which show why it was necessary that this be made without notice, what's the urgency of it, evidence of the respondent's assets, evidence of a real risk of dissipation. That's quite difficult to prove, so the courts take a sort of flexible approach to it. Obviously, it's difficult to prove that someone's going to dissipate assets before they've done so, because you can never really know what their intentions will be, but it's about the risk of that happening. A good arguable case, so not necessarily more than 50%, but something that's the court will regard as a reasonably strong basis for seeking a freezing order. Any defences that the respondent might have. So this is where the duty for full and frank disclosure kicks in, because of course these applications are made without notice. So in an ex parte situation like that, you have to put draw to the court's attention any defences that the respondent might have, and you have to be very careful about doing that. I'll talk about that more later, but there are very severe consequences if you fail to do so. And lastly, any insolvency issues, because of course if the respondent is insolvent, then that puts a hold on all enforcement proceedings. because it's not necessary, and also because you would be, by enforcing against his assets when he's insolvent, you would be getting a preference over other creditors. You'll also need to provide undertakings to compensate in damages for any loss caused, to an undertaking to issue the claim form and proceedings if they haven't already been done so, if this is a pre-action application. You'll need to undertake to serve copies of the affidavits and so on the respondent. And importantly, you'd also need to undertake to serve a note, a very detailed note of what was said at the without notice application, so that the respondent can have a fair hearing and can fairly know what's been said about them behind their back. Yeah, so I think that was on the wrong side there. That means you'll need a return date, and the onus will be on the applicant to facilitate the return date, and the respondent will of course need time to provide an affidavit which will set out the details of their assets that they hold. Starting point for that will be 7 days, but of course that's flexible if there's anything particularly difficult for the respondent to address, or if it's over the Christmas break or anything like that. What is a freezing order against a mortgaged property? Is the freezing order against the proprietor's equity in the property rather than the full property value? This is from an anonymous attendee. It's a good question. So a freezing order will normally be made against all assets that the respondent holds. If you're going to have generally, yes, it will prevent them from dealing with the property that's mortgaged. However, it has to be said that if a third party, like a bank, for example, holds a mortgage over a property, then that security predates the freezing order. So there's nothing to stop the bank from selling that asset to pay its mortgage. Although of course the bank would then have to hold any excess proceeds of sale as frozen assets pending resolution of the freezing order. Right, so where was I? Right, next slide. So when to make the application? Usually before proceedings begin. So for example, in cases of fraud, if you issue a claim against the fraudster and serve them a notice and send them a letter before action and all that sort of thing, you're going to tip off the fraudster that you are on to their fraud. So before doing that, you would make a pre-action application for a freezing order. There are, of course, you can also make it post-judgment. It'll be granted normally more readily post-judgment, particularly where there's been a failure to engage in cooperation relating to a judgment debt, or where the respondent has failed to give an undertaking that he will pay debts ordered to be paid, a judgment debt, and the time for payment has since gone and he's in breach of that order. Also, post-judgment, they're particularly useful when the judgment has made a finding of dishonesty against the party. That, as I said, strengthens the case for a risk of dissipation. And lastly, of course, it can be made during proceedings if, for example, as often happens in mortgage fraud cases or property disputes, if there are bank statements disclosed. I've seen this happen a number of times. If bank statements are disclosed during proceedings and they're clearly doctored, that kind of fabrication of evidence would be justification for making one during proceedings, even if it hasn't already been made pre-action. So things to look out for: bankruptcy petitions or insolvency proceedings, which, as I said, would make enforcement redundant and impermissible. It's important to be aware of the relevant court guides, so the Chancery Guide, Queen's Bench Guide, Commercial Court Guide, which set out particular administrative details like where applications need to be made to, what needs to be provided, and so on. It's also important to make sure you advise the clients of the costs of these applications. They're very labor intensive, so they're not cheap. And even in a strong application, there are inherent risks because, of course, you're dealing with, as an applicant, you're dealing with an incomplete picture where you don't know what assets the respondent has. And you're trying to essentially guess what the respondent's intentions are when you're kind of in the dark to an extent about that. It's also important to advise clients of the significance of this duty of full and frank disclosure. Matters of fact in law that might be adverse to your case. Obviously, a client might not understand, depending on the level of sophistication, they might not understand why you appear to be helping the other side in things that you're telling the court. If it's, for example, post-judgment, and if a judge has made criticisms of the credibility of your witnesses, unfortunately, you're just going to have to be very clear about telling the judge about those unfavorable things that's been said about your client. So it's important to explain that to your client in advance so that they're not not quite upset at the things that you're telling the judge about them when they'll no doubt disagree with them. Important also that full and frank disclosure addresses any danger of infringing the respondent's privilege against self-incrimination. So in terms of the affidavit that they have to file disclosing their assets, the court won't want to put them in a position where they have to, where it's ordered them to self-incriminate themselves. And also, of course, it's important to explain to the client the consequences of failing to meet the full and frank disclosure obligation, which can result in indemnity costs against your client. So that's a whistle-stop tour of freezing orders. The second issue I'm going to talk about are third-party debt orders. I think I'll try and keep this to another 5 or 6 minutes and then hand over to John so I don't run over time. So these are available under CPR 72. They allow a judgment creditor, so a claimant, to secure sums owed by a third party, such as a bank, to a judgment debtor defendant. So generally, as with freezing orders, these are made without notice to avoid the risk of dissipation of assets, to avoid the risk that the defendant's simply going to withdraw everything in their bank accounts and you'll never see it again. The difficulty with third-party debt orders, however, is often that you won't know what bank accounts someone has. Exceptions to that, of course, are where bank accounts have been disclosed during proceedings, as I've said, often in mortgage cases or that kind of thing, or where the parties have had a financial relationship before. You'll know at least some of the bank accounts that they have. And then just to touch briefly on a question asked by Manpreet Kaur of DAC Beechcroft. He asked if we could have a quick guide on applications for an order that a debtor attend court for questioning. This is something we can deal with third-party debt orders. They're allowed by CPR 71. And they can require the court can order that a judgment debtor come to court to be questioned on oath by a court officer about their means. If they fail to attend, proceedings for contempt can be brought against them. The weakness of this, of course, is that as soon as you do that, it's almost certain that the judgment debtor will realize that you've got their bank accounts in their sights and might take actions to evade at that stage. These applications can be made at any time after judgment. So it's important to note that the debtor doesn't have to be in breach. They're not, the courts don't regard it as an enforcement procedure in itself, but rather as a process for obtaining information to allow judgment creditors to decide what means of enforcement should be used, or indeed whether enforcement's worthwhile at all. It's also worth noting that these applications can be served on judgment debtors abroad, because of course by virtue of the fact that the court's engaged in the litigation process and they haven't objected to jurisdiction after acknowledgement of service, the court will of course have jurisdiction over them. Then dealing with the procedure for third-party debt orders, I should say. There's two stages. First, an application for an interim third-party debt order, and second, an application for a final third-party debt order. The application form has to be verified by a statement of truth, and because it's ex parte, you need to include any full and frank disclosure. It'll be dealt with by a master or district judge on paper without a hearing, and then the final hearing will be not less than 28 days after the interim order. Worth also noting that you need to check first whether the debt respite scheme applies or the mental health moratorium applies. And as I said, with freezing orders, check whether any insolvency restrictions are in place. So I'll just try and wrap up quickly the last of this. So third-party debt orders, as opposed to orders that the respondent attend for questioning, third-party debt orders, both the debt and the third party must be within the jurisdiction. The debt must be already due and involve an unconditional obligation to pay the judgment debt. It can be rent liabilities, it can be judgment debts. It cannot include salary yet to be paid. And then lastly, I want to deal with a question that I think Hannah Parry at Waitman's has asked. She asked, how would you go about making recovery from a pension? I think the point that Hannah's getting at here is that in bankruptcy, pensions are afforded a special statutory protection. That was considered in Blight and Brewster by Moss QC, sitting as a Deputy High Court judge. The applicant had been a victim of fraud and forgery and applied to enforce an order for payment of a judgment debt against the pension. Moss QC held that he had jurisdiction under Section 37 of the Senior Courts Act, which extended to granting an injunction or appointing a receiver to help with the enforcement of an injunction. And he held that there appears to be a strong principle and policy of justice to the effect that debtors should not be allowed to hide their assets in pension funds when they had a right to withdraw monies needed to pay their creditors, and ordered that the defendant delegate to the claimant solicitor the power of election, which would then ultimately allow the solicitor to make payment of the pension funds to the claimant. I should qualify that. Obviously, it's an equitable remedy. That was clearly a case which merited equitable intervention, but of course it will therefore be a discretionary remedy, so it'll heavily depend on the facts of the case. And then very lastly, I'll just touch quickly on contempt. That's dealt with under CPR 81.3. It'll usually be in the context of existing proceedings, so it's under CPR 23. You'll need the court's permission. The only thing I'd say about this is, whilst it shouldn't be ruled out, you do need that stick generally to be in the back of defendants' minds. It is an extremely expensive process. It's high risk, and it's of limited use, particularly when you've got a very recalcitrant defendant. And of course, the last point to make about this is that civil judges generally don't like sending people to prison. They'll generally tell people not to do something once, and if they do it again, they'll tell them not to do it a second time, and so on. But it is something that you need to think about, I think, in serious cases of disobedience. We'll come to some other questions at the end of it, but that's me for now. I'll hand it over to John Bryant now, who's going to talk about other enforcement issues. John, have you got your screen on?
There we are.
Great.
Thanks, Conor. Conor, are you able to enlarge the screen a bit or not?
Yeah, I can. Let me try.
That's it. I think one or two people are.
Oh, yeah. I think what we'll do is try that.
That's it. Thanks. Right. Well, afternoon, everybody. I'm going to deal with four main ways of execution, although we'll come to see that one of them isn't really execution at all. Attachment of earnings, control of goods, charging orders, and then insolvency. Now, this will be a whistle-stop and not much stopping tour, I'm afraid, because these are actually quite big subjects in themselves. So we'll get through in time, I hope. Now, attachment of earnings. The source of the law is the Attachment of Earnings Act 1971, and the procedure is in Part 89. And if we could go to Conor, can we have the, there we are. What are we talking about? An attachment of earnings order, as you probably know, directs the debtor's employer to pay part of the debtor's wages or salary to the collecting officer of the court, who then passes on that money to the creditor. Now, the minimum debt that is required to give this jurisdiction is £50. So if there's anything for less than £50, and who'd waste the money anyway, you can't use this procedure. Why would you apply for an order? Usually where the debt's not great value and the judgment debtor really has few assets, his main asset is his earning capacity. And it means that at least you'll be, unless the debtor loses his or her job, you'll be getting some regular payments towards the satisfaction of your debt. You can't apply for one of these orders in some what are obvious cases if the person is self-employed or unemployed, and who'd want to chase anybody unemployed anyway, and because of the definition of earnings in the statute, you'll find that members of the armed forces and merchant seamen are exempt from these provisions, but there are other ways of getting at those people like soldiers. The application is made to the County Court Money Claims Centre, and what the court does is send a form to the debtor, an N56 reply form, seeking the information as to whereabouts and means and so forth. And it's very important that the debtor replies with that form. Doesn't comply, he would have to show cause why he shouldn't be imprisoned, and if he fails to attend a hearing, the Act provides for imprisonment in default. And the court at any time might send to the employer a request for a statement of the debtor's earnings, depending on what the debtor has shown on the reply form. If the court officer has the reply form, thinks he or she has sufficient information to make the order, then he'll make the order. If the debtor doesn't like the order, there can be a reconsideration of it, and there will be a hearing to decide whether or not the order should be varied. These orders can come to an end. This is section 9 of the Act. The court can make an order discharging or varying an attachment of earnings order. So if you find that the debtor is earning more money in the employment than originally, you can apply for a variation. If the debtor loses his or her job, then the order will lapse. But that doesn't mean that the order isn't enforced for other purposes, and of course the debt remains. That was attachment of earnings. Another way of enforcing, and quite a common way, is if the debtor hasn't got the money, well, the debtor might have some goods. And you can seek an order that for the taking control of those goods and for the eventual sale. What the Act does is to apply Schedule 12, which is a long schedule of some 69 paragraphs. So you'll be glad to hear I'm not going to go through that. But it sets out the procedure for taking control and eventual sale of goods. And you can see that the system has, the newish system has replaced the old system of veri facias and all those Latin terms. In the High Court, there will be a writ of control issued. In the County Court, it's called a warrant of control. And it enables an enforcement agent, who would be a bailiff in the County Court or an enforcement officer in the High Court, to be instructed to attend the debtor's premises and take control of his or her goods. And then, as I've said, there's an ultimate power to sell the goods and use the sale proceeds to discharge the whole or part of the judgment debt. The procedure is set out in Schedule 12. And you can see there, notice is given to the debtor. The debtor either makes contact with the enforcement agent and pays the debt, or perhaps enters into arrangement for the payment of the debt. If neither of those happens, then the enforcement officer can take control of the goods. And there are 4 ways in which he can do that. Thanks, Conor. The next slide, please. Thank you. Now, having taken control of the goods, the enforcement agent will then sell the goods at public auction, or if the enforcement agent can apply to sell it by another method, but the default is at public auction. Now, to get one of these orders, the creditor makes an application in accordance with the Part 23 procedure as modified by Part 84. If there are no pre-existing proceedings, you have to go to the County Court. Now here there will be a judgment debt, so there will have been pre-existing proceedings. You apply to the High Court or the County Court. If you're enforcing for a judgment debt, or what remains of a judgment debt of £5,000 or more, you have to go into the High Court. If the debt is a small debt of less than 600, there is only the County Court. But there is provision for using either the High Court or the County Court. There are also in the rules, in Rule 84, provisions for the enforcement agent to make various applications to the court in order to ease the task of taking control and eventually selling the goods. Conor, thank you.
Yeah.
Now, not all the debtor's goods are going to be subject to this procedure, and Schedule 12 defines what are called exempt goods. Well, I'm sorry, Schedule 12 refers to exempt goods, which one can't take control of, and the regulations, so you have to read the regulations with the schedule, define what are exempt goods. And I've given a couple of examples of that. Another example is goods that are taken on hire purchase. Those might be exempt goods. So you'd have to go to the schedule, but the enforcement officers know very well what they can take and what they can't take. If for some reason the enforcement agent has breached any of the provisions of Schedule 12, or if the writ or warrant was defective, then the debtor can bring proceedings for the return of his goods or for damages for any loss that has been caused. And that will be under Rule 84. Now, I've said that the debtor could come to an accommodation with the enforcement agent instead of the enforcement agent actually seizing and then selling the goods. The debtor could enter into a what they call controlled goods agreements. Now, under this, the debtor retains custody of goods, but acknowledges that the enforcement agent has the right to take control and agrees not to remove or dispose of them, and certainly not allow anybody else to do so before the debt is paid. So it's a sort of a pledge. Now, the requirements set out in the regulations for the enforceability of these agreements, and they have to be strictly observed. I've put them there on that slide. The important thing is that the debtor has to be over 18, must be an adult. If the debtor wrongfully interferes with this procedure and the creditor suffers loss, the creditor can bring a claim against the debtor in respect of that loss. That's in Schedule 12, paragraph 67. And the schedule also provides for various offences really aimed at the debtor or the debtor's friends of intentionally obstructing an enforcement agent or intentionally interfering with the controlled goods without lawful excuse. So that was taking control of goods. The next thing are charging orders. We've looked at the debtor having a bit of money, but not much. The debtor having some goods against which you can enforce. When it comes to charging orders, the main thing that and the most common scenario in which charging orders are used is where the debtor has some land, usually the dwelling house. And you have to think a little bit before deciding whether or not to apply for a charging order. You want to know, first, is my judgment debt due and enforceable? And find out as much as you can about what resources the debtor has. And Conor has already said that you can apply to the court to get the debtor to reveal his assets. You're going to aim mainly at the house. And if there is a house, who lives there? You might have been able to find that out during a trial. That might have come out during the trial. And what might be the equity? Well, that might be some difficulty, but I have one recently where we just looked at the land registry and saw that there was a mortgage taken out some 30 years ago for quite a small amount. And that seemed to be the only charge. And so then we had just a drive-by valuation, or go on Zoopla and have a look at what the value of the house may be, and then work out, well, there's probably quite a lot of equity there. Let's have a go at getting a charging order. You also have to consider if there are other debtors. You might not know whether there are other debtors. Of course, a mortgage will show on the register, and whether or not another debtor might object.
I should say, John, it's almost always my experience of these cases that as soon as you go after someone's house, there will be a never before mentioned deed of trust that appears, in which the debtor's spouse or somebody else holds 75 or 90% property beneficially, and then you have to go through that rigmarole as well.
Yeah,
that,
I'll come to that, but that's absolutely right. I mean, you will see that you have to give notice to various people, be a spouse and anybody living there, for them to show cause why the order shouldn't be made. Now, the sources of law, the Charging Orders Act, obviously case law, and Part 73 of the rules with the practice direction. I set out there section 1 of the Act. The important thing to remember is that the court has a discretion whether or not to make the order. And the other point to make is that the sum of money, which is the debt you want to secure, doesn't include an award of damages to be assessed or costs to be assessed. You need a fixed sum. So it would be the sum awarded under the judgment plus accrued interest and costs, provided those costs have been quantified. You might have had an interim order for costs. Okay, thank you. Conor?
sorry.
Thanks. There are 4 types of charging order. The one that I'm going to deal with, and the most common, is the one on land. But there are 3 others that I mentioned there. And then we go on to the appropriate court. If the order was made in the High Court and exceeds £5,000, you can go either into the High Court or County Court. In any other case, the appropriate court is the County Court. There are 3 stages. You apply first of all for an interim order, and then for a final order, presuming you've got your interim order, and then there will be an application at some point for sale. The interim order is usually dealt with without a hearing by a court officer in the CCMCC, unless the court officer thinks it ought to be dealt with by a judge. There's some complication or high value. If we can go on, Conor. And if the interim order is made on paper, then obviously it will be served on the debtor, and the debtor can request that the order be reconsidered by a district judge. At this stage, as we've seen under section 1, in any event, the court has a discretion whether or not to make the interim order. But what happens in practice is that the interim order is made. It's very unusual not to have the interim order made unless it's going to be oppressive in some way. And then the discretion comes to be exercised when the final order is applied for. And the applicant should really set out in evidence why the order should be made, the amount of the debt, obviously, and the history of non-payment. The effect of the interim order is that a charge imposed by the interim charging order is ranks as an equitable charge created by the debtor. So there will be an equitable charge over the land, and it's then once you've got that, the court will then decide what's going to happen in relation to a hearing for a final order, and will give notice of such hearing and allow the debtor to object. Conor, thank you. There are various people you've got to serve the interim order on: the debtor, any co-owner that's shown in the land on the register in the land, a spouse or civil partner, and any other creditors that the judgment creditor knows about. If the judgment debtor is the sole owner, then you've just charged the legal estate and the beneficial interest in it. If there are joint debtors and they own the whole beneficial interest in the land, then the legal estate held by them should be charged. And if, as is common, and this is the point that Conor made, if the judgment debtor is a co-owner with somebody else who's not a joint debtor, then you charge only the debtor's beneficial interest. And of course, there may have to be, during the course of the proceedings, some decision made, and there'll be part of the litigation, as to whether or not the non-debtor co-owner does have any beneficial interest, and if so, what. The most important thing to do once you've got your order is to register it in order to get priority over any unregistered charges. It is very important. Then we come to the final hearing. Anybody, the person who objects, must serve evidence before the hearing, not less than 7 days. And then at the hearing, the court can make the final charging order, make the charging order final, discharge it, decide issues in dispute, direct a trial of those issues. So it might be as to the beneficial interests, and make other directions as appropriate. Now, I've said the court has a discretion, very important. Under section 1.5, the court has to take into account the personal circumstances of the debtor and whether other creditor of the debtor would be likely to be unduly prejudiced. But it goes further than that. If I might go to the next slide. Now, the burden is probably on the judgment creditor. The law is not quite settled about this, but it looks as if the burden is on the judgment creditor to show why he or she needs the protection of the order, rather than the burden being on the debtor to show why the order shouldn't be made. The discretion, in exercising discretion, the court can take into account what's happened, if anything, since the interim order, and the hardship that will be suffered by the judgment creditor if the order isn't granted. That's important, and I'll come to deal with that on the next slide when we come to deal with sale. Now, usually the final order will have been made if there is a commercial creditor who's being kept out of the money. You make the final order. It doesn't mean that there will eventually be a sale. That might take some time, months or even years, before you're in a position to apply for a sale, simply because of there might be young children in the house and you might think it's not worth applying. Where the debtor is not the sole owner, then, and is the owner with somebody else, obviously, then the land will be held on trust. And then you have to bear in mind, when you come to make an application for sale, the Trust of Land and Appointment of Trustees Act, TOLATA. And you'll see that you make the application under section 14 of TOLATA, and the provisions of section 15, which deal with the discretion, come into play. If we can go to the next slide.
John, I'm just conscious of the time, and I can see that we've got 7 minutes left. So should we jump to the?
Well, I just want to say this: that
you'll
see on the slides that TOLATA comes into play if there's a sole owner who has the sole beneficial interest. Tolata doesn't come into play, but still there is some authority that the family's interests will still be taken into account. On the whole, though, when it comes to a sale, the interests of the creditor not being kept out on the money weigh fairly heavily. Okay, well, that's all I want to say about that. Now, I've done a few slides on insolvency, not very much, and I've separated them between winding up and bankruptcy. Strictly, you'll see on those slides that neither winding up nor bankruptcy is actually a form of execution. The judgment creditor is seeking payment, probably with a lot of other creditors, and certainly by the time that the petition is issued, other creditors might well come on board. And you'll see in the slides that I've dealt with in bankruptcy some of the obvious advantages and disadvantages. Insolvency is the nuclear weapon. The courts don't like it being used simply to collect a debt. But if you've tried to exhaust all other remedies of executing judgment, then perhaps you are left with insolvency. And I'm sorry I haven't got time to deal with it, but the slides are there for you.
Yeah, those slides are very detailed slides, which are very useful for considering winding up an insolvency. So just now, in the last 5 minutes, to touch on some questions that have been asked. Rohit Stalakar from LMK Law asks, how does the current COVID-19 situation affect enforcement on commercial premises where a landlord has a judgment for rent arrear? Well, it's something I think John has referred to in those slides. There are, during the relevant period, which at present under the COVID insolvency legislation extends to the 25th of March 2022, I believe, puts in place restrictions applying in relation to relevant business tenancies. So a right of re-entry or forfeiture for non-payment of rent may not be enforced by action or otherwise. If High Court proceedings have already commenced to enforce a right of re-entry and forfeiture for non-payment of rent, any possession order must ensure that the tenant does not have to give possession before the end of the relevant period. And so the question was about judgment for rent arrears. Where the High Court has already made an order for possession to enforce a right of re-entry or forfeiture, then the High Court must ensure that the tenant does not have to give possession before the end of the relevant period, and so on. There are other restrictions, but very much, yes, COVID-19 does affect enforcement of commercial premises rent arrears. The next question, and of course there's much more detail to that, but I think that would warrant the talk in itself, the COVID restrictions for the relevant period. The next question I'm going to turn to quickly is, and is there anything you want to say about that, John? I know you'd talked about the COVID legislation.
Yeah, you'll see in my slides, obviously you can't present a petition. We'll see what happens at the end of March.
Yeah.
And you probably know there is a bill. I don't think it's gone through Parliament yet, but there's a bill presented in November dealing with rent arrears. This is before judgment, but rather than get people come to court to try and pursue all the rent arrears that have backed up over the COVID period, there is going to be a system of arbitration and negotiation. I think this is probably to save the courts being flooded with claims. Now, I think the intention is that will come into effect at the end of this relevant period, ending in March. And there will be a new regime for chasing rent arrears.
Yeah. Yeah, very interesting one to watch because it still has to be finalised, that legislation.
Yeah.
Right, so Anne Saunderson from Foster's Solicitors has asked how best to enforce an order for pre-action disclosure. Very good question. I think you'd start by looking at CPR 3116, which deals with pre-action disclosure, and CPR 3121, which provides that the consequences of a failure to disclose documents or permit inspection are that the party may not rely on any document which he fails to disclose or allows to be inspected unless the court gives permission. So I suppose one thing you could do is to issue proceedings, and then the defendant wouldn't be allowed to rely on the documents in question. Or you could, if you're a defendant, you could apply to strike out a claim for failure to comply with the relevant order. If a party makes a false disclosure statement, then of course you can have proceedings for contempt. Although I'm not sure, as I said, that's an efficient approach. I think I'd need more detail about the situation in question, but one thing I would warn against is trying to get a search order. Search orders, closely related to freezing orders, are only for the preservation of documents and not meant for the not meant to be used as a means of obtaining documents. Then moving on to the next question from Carl Jaffer from MFN Claims. He asks, what's the best course of action? It's a similar question. What's the best course of action when a defendant has not complied with a court order for provision of documentation? So I'm not clear if this relates to whether there's well, what it relates to really, if it's a disclosure question. But assuming it relates to disclosure, the same answer as with Anne Saunderson's question. The party cannot rely on that document, and it seems likely that the court does have very wide case management powers under CPR 3.4, I think, off the top of my head. And of course, the ultimate sanction is unless disclosure is, the order for disclosure is complied with, the claim or defense, whichever it may be, would be struck out. And then the last question that's been asked by Christopher Arnold at Deloitte. Christopher asks, can parties control enforcement in contracts? Again, I wasn't sure what this referred to. Parties, of course, can agree remedies remedies for breach under the terms of a contract. But if the question's getting at some kind of specific performance, that isn't something the court's going to get involved in unless you're dealing with a unique asset like land or shares. And then I think the only other point to be made, I think John might have mentioned the various securities, the various charging orders that you can have. Of course, before the breach of contract arises, one can have security. So it can be, you could have a floating charge over assets, or obviously a mortgage, and banks will usually have mortgages over properties when they make a mortgage loan to consumers. So yes, very much there is great scope for setting out various enforcement protections in contracts, which just gone to 1:02. So we're out. I can see more questions from Ute Wall and Ollie CPR coming in. Kind of very good question. Can a shadow director of a corporate judgment debtor be summoned to court under a Part 71 order? I think it needs to be a party to litigation. I don't think Part 71 orders can be used for non-parties. I think what you'd want in that situation is to basically seek a sort of non-party disclosure order, rather than going through Part 71. But it's a very good question. Yeah, the shadow director would complicate matters. I mean, you'd probably want to make them a party to proceedings if they are a shadow director. But yeah, very interesting question. And then one I think probably for John, Ute Wall says, what if the debtor, I think this is in relation to enforcement of private goods, what if the debtor is a private person and does not communicate with the enforcement agents and does not open the door to them either?
Well, I think then the enforcement agent would go back to the court and try and get an order that the debtor would have to show cause, because actually could be punished criminally, because as I said, the schedule to the Act, Schedule 12, makes provision for various offences, and I think the debtor interfering with the process like this might well be an offence under the schedule. But I suspect that enforcement agents, bailiffs and so forth, know what to do in these circumstances. I suspect it's not uncommon. And they will simply go back to court and get the debtor summoned, I would have thought.
Thanks, John. Very helpful. And then one last question just appeared from Jamie Valls. To what extent is post-judgment interest, say under a CCJ, covered by the charging order?
Yeah. What you do is at the interim stage, you calculate not only the judgment itself, you add the interest that's accrued since judgment, and then you take the new figure, put that in your evidence, and seek to have the charge on the property in that sum. And then when you come to the final order stage, you can recalculate the interest again and use that figure as the figure that is secured by the charge, with interest to accrue.
Yeah, you charge it, you calculate the daily rate, don't you? Because it's simple interest, not compound, so it's quite easy to calculate the daily rate that.
Well, it would be the judgment at rate. It would be the 8% if you've got it at 8%.
Yeah.
With the judgment at rate.
Great. Thanks very much for that, John, and thanks everyone for attending. And in particular, thank you to the various people I've mentioned who asked questions. I hope I've answered all of the questions. There's every chance I've missed one. As we've gone, given the time constraints and just the management of these slides. Hopefully it's been legible for you. Before we go, I want to just flag up a very good talk we've got in 2 weeks' time by Francesca O'Neill and Henk Sood. Wednesday the 23rd of February, they're going to be talking about assessment of damages in professional negligence claims. Very useful because, of course, it's a fiendishly complex issue. It's not just a sort of ordinary but-for test that is applied, but rather there's complex questions of the scope of the duty and causation and so on. So a really interesting topic with lots of recent case law, including some Supreme Court cases that I'm sure they're going to talk about. So tune in for that not next Wednesday, but the Wednesday after, the last Wednesday in February. Thanks again for coming, everyone, and do feel free to follow up with any email questions.